Good morning, everybody. I'm Nina Gardner, adjunct professor in the International Law Department of Johns Hopkins SAIS. It's great to have a good group this morning, and today we are going to be discussing COVID and constitutional law. We have an eminent professor we're very, very lucky to have, the head of our very own International Law Institution's interim director, Stephen Schneebaum, who has been with SAIS in many different capacities for 30 years. 30 years. That shows real loyalty, and we are so grateful. He has also been the Jessup advisor, by the way, for as many years, and has brought the Jessup team, which, by the way, SAIS does not have its own law school, so it's against international law schools and domestic law schools, and the Jessup team from the ILAW department has reached the international rounds in 2015 and this year. So congratulations to that. So Professor Schneebaum has also been, of course, a practitioner for many years, is a litigator, and has been over 25 years at Patton Boggs and Blow, one of the major law firms in this country, and other law firms, and is an expert on a number of issues, from international law to European Union law to all sorts of civil litigation, public international law, arbitration, etc. He has been involved in criminal justice reform and in criminal justice for many years, has been representing pro bono, I may say, a number of people on inmates on death row, and is at this moment helping an inmate in a major litigation in Alabama in the 11th Circuit. So that is a really something that I admire a great deal. But we have someone really who can span both the international law, the domestic law, and all sorts of questions in between, and we are fortunate to have him in this period where it's not quite sure what our executive, and especially our president, knows about constitutional law. And I was hoping with the tension between the states and the federal government and the courts, maybe Professor Schneebaum can shed some light as to the general confusion occurring during these weeks. So I leave the floor to you, Professor. I will be asking everyone to hold their questions until Professor Schneebaum has ended, and then please send your questions in the question and answer box as opposed to the chat box, and I will curate and try and get to all of you. Thank you very much.
Okay, well, thank you very much, Professor Gardner. Very nice introduction. And of course, those of you who are SAIS students, and particularly SAIS ILAW students, some of what I'm about to say may be a bit familiar to you. But what I want to focus on is how and to what extent this current crisis that we're living through affects the Constitution, and how the Constitution affects all of us in a time of crisis. And I think it can fairly be said that since 1787, the Constitution of the United States has been characterized above everything else by one particular characteristic, and that is its resilience. It has seen us through all kinds of upheavals. It has seen us through civil war. It has seen us through cultural shifts. It has seen us through the end of slavery, through the beginning of the recognition of the legal rights of women. It has gotten us through very many crises, and it has survived. It has survived those crises almost intact. The number of amendments to the Constitution over these 200 and some odd years is very small, 27, really 25 if you don't count the two that cancel each other out, in all those years. And so it's seen us through crisis after crisis after crisis, and it has survived until now. And so the question is, does this current debacle that we're living through threaten the constitutional order, and how does the Constitution respond to the kinds of difficulties that we are seeing? And Now, when I teach my constitutional law class, as currently going on at SAIS in the spring semester, I divide my approach to the Constitution into three parts. I talk about the Constitution as the blueprint of government, as the protector of rights, and as an engine of social change. The first two of those, I think, certainly have bearing on the subject to be discussed today. I think it's a little early to talk about whether the Constitution will act as an engine for social change going forward after this, after we get past this current difficulty. But I do propose then to start out by talking about how the Constitution lays out the government and assigns various functions to different entities, because a lot of what we're seeing, a lot of what's been in the newspapers over the last days and weeks has had to do with who has responsibility for what, who has the power to do what in this constitutional framework. So there are two aspects, of course, to the allocation of powers that the Constitution mandates. There is the separation of powers between the federal government and the states, and then the separation of powers among the three branches of the federal government itself. So I want to focus first on the difference or the interaction between the government of the United States, headquartered here in Washington, and the governments of the 50 states headquartered in their various capitals around the country. We start from an important premise, and it's a premise that was very much the inspiration for the Constitution and remains so to this day. The United States government is a government of limited power. It is a government whose powers are spelled out or are implied by the Constitution itself, and the Constitution made it quite clear that it is not intended that the federal government may exercise powers beyond those conferred by the Constitution. And indeed, that was part of the reason for adopting the Constitution in the first place, because after all, as some of you will be familiar with, at the time of the American Revolution, the first effort to govern the 13 colonies, now newly independent states, was a failure. And it was a failure in large part because of the inadequacy of the allocation of responsibilities between the federal government and the states. But the idea that the states would retain their power in large areas of governance has certainly never been abandoned. It's very much baked into the Constitution. And in fact, you can even see it in the Declaration of Independence itself. You know, Thomas Jefferson's masterpiece, which begins, that's the one that was signed on July 4th of 1776. It famously begins by making reference to, and I'm reading it now, or at least I hope I'm about to be reading it, to the 13, here it is. This is the action of the Second Continental Congress, July 4th, 1776, the unanimous declaration of the 13 United States of America. And there's a very interesting thing about that. If you look at the actual document, the actual handwritten document, the word United States of America, is not capitalized. And that's very significant because it was not necessarily contemplated that there was going to be a country called capital U, the United States of America. It was contemplated that there were 13 states and they were united for some purposes, but not for others. Well, the founders then remained clear, and we should remain clear, that the states retain sovereignty and that the federal government has authority only over things that must be regulated at the national level in order to achieve two primary goals. The first goal was economic efficiency. That is, to speak in today's European jargon, to create a single market. The purpose here of provisions of the Constitution that forbid the states from issuing their own currency, it forbid them from from posting tariff barriers against each other and all that, was to create a single market, just as the European Union is striving to do today. The other feature that is raised to constitutional level was one that perhaps was even more important to the founders, and that was the protection of individuals against government overreach, against the kinds of abuses that Jefferson complained about and put at the feet of George III in the Declaration of Independence. We're not going to permit the quartering of soldiers in people's homes. We're not going to permit the restrictions on freedom of the press and freedom of religion, freedom of assembly, all of those things. Now, of course, those were not included in the document that was the Constitution adopted and ratified following 1787. Those rights were protected in the first 10 amendments to the Constitution, which were not incorporated into the original document. And there was much debate about that at the time. The Federalist Papers go on about this at great length as to whether it would be sensible to list rights or to describe them and to put them in the Constitution or have them be separate. And of course, the outcome was that the first 10 amendments describe the rights that everyone has. Of course, everyone in those days except certain people who were, for example, enslaved. But aside from that little problem, everyone would have the right to a fair trial. Everyone would have the right to freedom of religion and so on and so on. So those rights are protected at federal level, and the economic unity of the country is protected at federal level, and other things are left to the states. So the things that are left to the states include very important things that affect our daily lives: domestic relations, ownership of property, both real and personal, things like trusts and estates, and the protection, by and large, of public order, the so-called police powers. The police powers, the power to ensure that society can operate safely and securely, are reserved, except in special cases, are reserved to the states. And the founders made that very clear in the 10th Amendment when they wrote, "The powers not delegated to the United States by this Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people." Again, if you're familiar with European Union developments, this will sound familiar to you. This is the principle of subsidiarity, the principle that says that governance works best when it is as close as possible to the ground, to the place where things actually are happening. And that principle of subsidiarity is deeply embedded in the Constitution. So what does that mean? It means that every federal statute that is enacted by Congress, signed by the president, or comes into being over the president's veto, every one must be grounded somewhere in a grant of authority by the Constitution to the federal government. And where that cannot be done, where Congress overreaches, where Congress trenches on the police power of the states, the courts, which have assumed, since 1803 at least, the right of judicial review of legislation passed by Congress, the courts will strike such statutes down. And so, while sometimes Congress has been guilty of that kind of overreach, the courts have guarded against it. An example, there are many, but an example is the Violence Against Women Act, signed into law by President Clinton in the late 1990s. One of the provisions of that statute would have given the federal courts jurisdiction over gender-based violence against women. And the courts said, sorry, in the United States against Morrison, sorry, but there is no basis in the Constitution for that. And although we might all believe, we might all agree, in fact, I suspect everyone would agree that there should be a fast track to the courthouse when gender-based violence takes place, it is simply not the business of the federal government to address it. And so in US v. Morrison, the Supreme Court struck down the provision of the Violence Against Women Act that created federal jurisdiction where the Constitution did not. So anything that the federal government does, statutes, emergency declarations, proclamations, executive orders, treaties, anything of that nature must somehow or other find a home, find its roots in the Constitution of the United States. And that includes, of course, what we're seeing now. It includes things that are implemented, adopted, ordered by governors of states, lockdowns, quarantines, bans on travel to particular places, and so on. All of those things come within the scope of the authority of the states and not of the federal government, and therefore the ultimate decision makers will be state governing entities. And then what? Who? Well, it depends on what each state has done. Just as the federal government, federal Congress occasionally adopts legislation in which it exercises power on its own, and in other cases delegates that power to others, just so states do the same thing. And so we need to determine state by state whether individual state legislatures have conferred upon their governors the power to order things like lockdowns, quarantines, and so on. The federal government simply has no role to play here. Now, that's both good news and bad news, of course, right? Because the good news is that the federal government's attempt to mandate, rather than simply to urge or to recommend particular measures, is an overreach and won't be sustained. The bad news is, if your governor screws up, there's nowhere to go. If the governor makes a mistake, unless the mistake that the governor makes is of constitutional dimension, which is possible, but if the governor simply makes a bad decision, allowing the resumption of economic activity, for example, or continuing a ban on economic activity when there is evidence to suggest that it's no longer needed, those decisions remain at state level. And since we have 50 states, there's not necessarily going to be any kind of consistency or unanimity or smoothness in the operation of perhaps 50, perhaps even more than 50 separate systems. Now, this is cumbersome, clunky, inefficient, but it's not unique because there are many, many areas of US law that are governed similarly. Speaking as a lawyer, for example, I can't practice law in the state of Maryland unless I am sponsored by a Maryland lawyer, even though the Maryland border is 3 miles from where I'm sitting right now. There are different rules in Maryland, and Maryland gets to decide, and the District of Columbia gets to decide, and Virginia gets to decide who is entitled to practice law in their jurisdiction. So the lack of consistency is something that we are all too familiar with, and I'll be coming back to that theme again later on. Now, there has been a bit of press over the last couple of days suggesting that, that we liberals, and I confess, we liberals are being inconsistent in our insistence on states' rights at a time like this, because they say, look, back in the 50s, back in the 60s, and even more recently than that, states' rights, that slogan, states' rights, has been the shield behind which all kinds of reactionary movements have sought protection. And indeed, going back earlier than that, the battle against integration at the federal level in the 1960s was very rarely framed by those who opposed equal treatment for all citizens. They very rarely said, we're doing this because we believe Black people are inferior or something like that. They didn't say that. They said, this is a states' rights matter and it should be reserved to the states. So now we all opposed those notions back in the day, and now we seem to be supporting those same notions. Isn't that an inconsistency? Isn't that even perhaps hypocrisy? But the answer to that is emphatically no, and here's why. The Civil Rights Revolution, starting with Brown against the Board of Education, continuing through the Civil Rights Act of 1964 and various other statutes, was grounded in the Constitution. When the Supreme Court determined in 1954 in Brown that there is no such thing as separate but equal, they were applying provisions of the Constitution, and in particular the 14th Amendment, to declare that separate facilities for Black and white students in the city of Topeka were a denial of equal protection to some of our citizens. When the Civil Rights Act of 1964 was adopted, it was grounded in the Interstate Commerce Clause of the Constitution, which allows Congress exclusively the right to govern commerce between the states. And Congress declared, and the Supreme Court agreed, that regulating access to things like education, employment, public accommodation, and so on, all of those things are trench on the constitutional rights, including the right of equal protection. So the question here is not whether anybody agrees or disagrees with the notion that the states retain some measure of sovereignty. Of course they do. The question is, what is the perimeter? What are the boundaries around those areas of state sovereignty? They govern, they include the police powers, for sure, but they don't include police abuse. They don't include forced confession. They don't include denial of fair trials or excessive bail or cruel and unusual punishment. Those things are prohibited by the Constitution. The states are free to act outside those areas. And that's why there is no inconsistency at all between the defense of states' rights that was used as a masquerade for bigotry back in the day, or for other kinds of silly things more recently. There's no inconsistency between that and the position that I'm urging, which is that the police powers remain within the ambit of the states, and that the states have a great deal of latitude in determining what they are. Now, we see this issue arise not only in the context of basic rights, integration and so on. We see this same tension. Is this right a constitutional right, in which case it's properly within federal concern, or is it not a constitutional right, in which case it is properly consigned to the decisions of individual states? That was the guts of Roe v. Wade. That was what Roe v. Wade was all about. That was what Obergefell v. Hodges was all about, when the Supreme Court held that there is an equal protection right of gay couples to be issued marriage licenses when heterosexual couples are being given those same licenses. It was a question of equal protection. Therefore, it was a question to be resolved at federal level precisely because the constitutional obligations of the states were being triggered. And it's critical to understand that, because if you read, and my class in constitutional law has, I trust, read, and I hope some of them are listening, if you read the decisions, and particularly the dissents in cases like Roe v. Wade, Planned Parenthood v. Casey, Obergefell v. Hodges, you will see that the dissenters are not saying, well, let's take Obergefell, the gay marriage case. The dissenters are not saying, I don't think gay couples ought to be allowed to marry. I think it's against biblical law, or it's unnatural, or it's horrific, or it's a sin. They're not saying that. In fact, Justice Scalia, in his very powerful dissent in Obergefell, said, I don't care at all about gay marriage. It means nothing to me. But, he said, the question isn't whether it matters to me. The question is whether it matters to the Constitution. And I don't see that it does. Well, I think Justice Scalia was wrong. He couldn't persuade more than 3 of his colleagues to support his view by 5 to 4 in an opinion by Justice Kennedy. Of course, the right to gay marriage was upheld. And therefore, that means that states may not discriminate in their issuance of marriage licenses. Roe v. Wade means that states may not intrude on the privacy of individual women by prohibiting them from going through a procedure of abortion, at least up to the point of their fetus's viability. So it's yeah, please.
All right, could I ask you, because I just gotten a very good question, which I was going to ask you at the end, but this is a good place for it.
Sure.
From Sarah Bufano, who's asking whether you think this pandemic will create a movement to give the federal government authority over health issues. Because, and if so, how would states give the federal government that authority?
Yeah, very good question. I think that, and in fact, I was planning to end with this, but thank you for anticipating it. I think that one issue that we might well give thought to these days is, does this system of divided sovereignty in something as important as healthcare continue to make sense? It's certainly, we've lived under this system for 200 plus years, but perhaps the very nature of a pandemic, which obviously respects no borders, domestic or international, perhaps that does cause some rethinking or provokes rethinking. However, it would, I think, require, I don't think there can be any doubt about this, it would require a constitutional amendment to do that. And whether the political will of this country has developed, I almost said matured, I don't want to show my hand quite to that extent, has developed to that point, is an open question. But so that's the answer. Let me come back to that point, because I think that's not the only question that we need to give some new thinking to as we emerge, we hope, from this current crisis. So when the president says, as he said the other day, when somebody is the president of the United States, the authority is total, well, no, it isn't. And when the vice president of the United States says, the authority of the president of the United States during national emergencies is unquestionably plenary, no, it isn't that either.
Okay.
There's nothing in the Constitution that supports that view. And even if, well, and there isn't, that's that. But even if there were legislation that provided for some kind of governance in times of national emergency, that legislation would have itself to conform to the strictures of the constitutional division between the states and the federal government. So now let's have a look. We've talked about the federal government and the states. Let's look within the federal government, the three branches, the so-called checks and balances that we hear about all the time. And obviously, we need to start out by focusing on the powers of the president, because that's what we're reading about all the time these days. The president has three kinds of powers under the Constitution. He has the powers that are expressly conferred upon him. That is, the Constitution says, for example, the president shall be commander-in-chief of the armed forces. So he is. That's that. He has that authority. It is directly conferred on him by the Constitution. There are other powers that he has that are implied by the Constitution, not written there, but that are implied there and that the courts have recognized and developed and shaped over the centuries. In particular, a good example, one of concern, I think, to this group, is the power to conduct foreign affairs. The Constitution doesn't say that. The Constitution nowhere says that the president shall be the spokesperson for the country or shall conduct the foreign policy of the country. It gives the president authority to sign and to ratify treaties with the advice and consent of the Senate. It gives the president certain powers with respect to things like receiving and sending ambassadors, again with the advice and consent of the Senate. The Constitution provides that Congress, not the president, shall declare war. That's a federal power, not a presidential one, but still a federal one. Other than that, there's very little in the Constitution that specifically addresses this issue. The idea that the president's authority is as broad as it has been over the centuries has been an idea developed by the executive branch and endorsed by the courts. And the deference that the courts will pay to executive actions in the area of foreign policy is very broad, but it is not unlimited. In 1952, the Supreme Court decided a case that this week has been in the mainstream media almost constantly. President Truman, during the Korean War, issued an executive order nationalizing the steel industry. And he did that because he had attempted to jawbone the steel industry into lowering prices to purchase steel so the government could purchase steel for use in the Korean War. It was an emergency. It was a serious emergency. There were Americans and Koreans, heaven knows, dying every day in Korea. We need weapons. We need the kinds of things that need to be built out of American steel.
Like ventilators.
Like, sorry?
Like ventilators, maybe
like
not
ventilators,
steel.
exactly. We need those things. This is an emergency. We need those things. And so when Youngstown Sheet and Tube and a couple of other steel manufacturing companies said, hell no, this is America, we don't do that. We will not give up our property without compensation and without due process of law. Read the Fifth Amendment, Mr. President. The case went to the Supreme Court, and the Supreme Court struck down the president's action. The Supreme Court held that the president had acted outside his authority, or as lawyers say, ultra vires. He had acted in a way that the Constitution did not permit. Now, the court, Mr. Justice Jackson, who had been the lead prosecutor at Nuremberg and was a great American jurist, Justice Jackson was very careful to map out in Youngstown Sheet and Tube where he thought the dividing lines are. Of course, this is only a suggestion. It wasn't part of the decision. But he said that there are the areas where the president can act that are conferred upon him by the Constitution, he's got free rein. Good luck. The areas that are prohibited to him by the Constitution, he can't do that. The Constitution binds the president just as it binds everyone else. And then there's this very broad area in between. And as to those, we will need to look for another type of presidential authority. So we've talked about express authority and implied authority. But there is a third, and it is most important. It is more important than the other two, and that is delegated authority. Congress regularly assigns to the president the power to do all kinds of things, to declare national emergencies for some purposes, to determine, just again to cite a random example, an area that we talked about both in my introductory class and in the constitutional law class. The president has been delegated, and he has assigned to the Secretary of State the power to decide what organizations count as terrorist organizations. And the consequence of that designation is that it is a criminal offense for Americans to support those organizations, financially or by their other kinds of contributions. That's the power, in effect. The president has been given the power to make critical decisions that may trench, possibly at least, on such areas as freedom of assembly, freedom of speech, and yet Congress has granted the president that authority. And the question, if this were ever to be tested in the courts, the question would not be, was the delegation to the president proper? The question would be, was this properly a federal function to begin with? And that, again, remains the critical issue. Is it a matter of police power? Is it something consigned expressly or by implication to the presidency? And if not, then how is it going to be justified? There is, of course, no federal legislation right now that confers upon the President of the United States the power to order a lockdown or a quarantine or a ban on travel. Indeed, it simply doesn't exist. States, if authorized by their own constitution and legislation, may do that, but the president may not. And therefore, again, the decisions that the president undertakes now in relation to the COVID-19 pandemic, must be evaluated first on constitutional terms and then second on statutory terms. Is there a statute that authorizes the president to do this? In the area of immigration, there is. The Immigration Nationality Act, and particularly it's for those of you who are lawyers or who are interested in the minutiae, it's 8 U.S. Code section 1182F, provides that the President of the United States may ban immigration of selected groups of aliens or of all aliens when he declares that a national emergency so requires. Now, some of you will remember the case of Hawaii v. Trump that went to the Supreme Court. That was the case that tested the selective immigration ban that picked out several countries of origin, which all happened to be, or all but one happened to be Muslim countries. All of them happened to be non-white countries, primarily at least. And when that case went to the Supreme Court, the question the court had to decide was whether the president's rationale for the separation, for the allocation, for the hair splitting that he did, why is Iraq not acceptable, but Jordan is acceptable? Why is Venezuela not acceptable, but Colombia is acceptable? Were those distinctions that he drew properly grounded, not in the Constitution, but in the kind of rational basis that any executive decision based on legislative empowerment must be? And the court concluded that the president is entitled to deference in this area, and because he is entitled to deference, we are not going to second guess him, and therefore they allowed the order to stand. When, not if, the current order, the one the president described yesterday and I think signed this morning, the proclamation banning all immigration within certain categories anyway, for 60 days pending renewal, it's not at all clear to me that the courts are going to subject that to the same level of scrutiny because he didn't make distinctions. So there are no distinctions that need to be defended. He simply said all means all. Now, of course, he didn't ban all immigration, just as when he, quote unquote, banned China in January, he didn't shut down all incoming traffic from China. New York Times reports that 43,000 people have come directly from China to the United States since this so-called ban. But here, I suspect that the courts may very well defer to the kind of distinction that the president made. Now, of course, when the president was asked the other day, how do you justify all of these claims, all these powers that you're claiming you have? He said, well, they're in the Constitution, and someone asked him what provisions of the Constitution. He had no idea. But it doesn't matter, really, from a constitutional law perspective. It doesn't matter what he knows or doesn't know. What matters is what the courts will accept and will not accept. And I suspect, although this is my prediction, it could easily be wrong, I frequently am, that these immigration bans will, in the end, be upheld. Now, there's one other function that the President of the United States plays, which really doesn't come from the Constitution, doesn't come from judicial implication, and it doesn't come from delegation. And that is the role that presidents have played forever. And, it was Theodore Roosevelt who used the expression bully pulpit. The president has a unique vantage point from which to speak to Americans. And we've seen that in our lifetimes. We saw President Kennedy talk to us after the Bay of Pigs catastrophe. We saw President Reagan talk to us after the Challenger exploded. We saw George W. Bush talk to us after 9/11. And so the president speaks from a pulpit, and I think that word is precisely correct with all of its religious implications. He speaks to us from a pulpit that is meant to inspire and to reassure and to resolve or to increase resolve. And whether this president has done that is, of course, a question that many people are discussing. But it is not, as strong as I suspect all of our views might be on this subject, it is not a subject that bears on constitutional law. Now, what about Congress in all of this? There's been some concern, Congress has been in the papers a lot over the last week or so, about whether they will adopt systems of remote voting in both houses of Congress. And is that consistent with what the founders anticipated? Well, I dare say the founders probably did not anticipate the internet, but that's really irrelevant. Did the founders insist upon in-person meetings of both houses of the Congress? And I think the answer is that if that is what they intended, they should have said so. They didn't say so. They said that each house of Congress may make its own rules, and the courts have routinely held that the adoption of those rules will not be inspected, will not be reviewed by the judicial branch of government. This is a signature power of the legislature. It makes its own rules and it can enforce them. And indeed, both houses, the two houses make their own rules separately. Obviously, the Senate has rules that permit, for example, filibustering. The House doesn't. The Senate often requires more than 51 votes to pass resolutions. The House always, or almost always, votes by simple majority. So I see, at least, no constitutional impediment against the adoption of a policy, a rule, a principle that would permit remote voting, remote participation. British Parliament, House of Commons did it just 2 days ago. And they go back, obviously, a lot longer than we did. The Speaker of the House of Commons began his introduction the other day to the new regime by pointing out that the last time that the Parliament had not sat in person because of a disease was something like 1346. Well, desperate times call for desperate measures. And it is open, I think, to the houses of Congress to make their own rules. There's also been some discussion over the last couple of days. The president has often been criticized, the current president has often been criticized for not filling executive branch vacancies. Many important executive positions, including ones in the Department of Health and Human Services, are empty or are occupied by people serving in an acting or interim capacity, speaking as interim director here. The Constitution provides that the president must have his nominees confirmed by the Senate, but if he appoints people to interim positions when both houses of Congress are out of session, then his interim appointees may exercise executive authority until the Congress reconvenes. Well, since time immemorial, Congress has had the policy of remaining in session during hiatuses, during breaks, by having pro forma sessions, often daily or every other day, that last 10 minutes, sometimes less, where someone convenes the House, declares the House in order, and someone says, I suggest the absence of a quorum. Of course, the quorum isn't there because it's like one person sitting on the floor, and then the House is adjourned, but the House is still in session. And that has been done precisely to rein in the executive, to prevent the executive, not just this president, but previous ones as well, including President Obama, to prevent him from using that interim appointment authority to circumvent the will of the legislative branch. President Trump has been heard to say lately that he has found authority in Article 2, Section 3 of the Constitution that says that if the two houses of Congress disagree about the date of their eventual adjournment, the president may adjourn both houses on his own initiative. But it seems, not only to me, but I think everybody whose commentary I've read on this over the last few days, that that provision, that power, may be exercised only when there is in fact a disagreement between the houses and not a disagreement between the legislature and the executive branch. What about the courts? Well, the courts will proceed as necessary. Obviously, the courts, like Congress, have had to make different arrangements. They are increasingly relying on oral arguments to be taking place by video conferences like this one, or by telephone. Speaking as someone who has done oral arguments by telephone, I absolutely hate it. It's very inefficient and really leaves everybody with a feeling of lack of satisfaction, but never mind. The Supreme Court has rescheduled its April arguments for May at the moment. They may, of course, end up needing to be postponed further. The Supreme Court has this term a number of very important cases in front of it. Cases ranging from another review of Obamacare to the question of whether the president may shield his personal financial records from a congressional subpoena, various other important cases involving gay rights, determining whether discrimination based on sexual orientation is a subspecies of sex discrimination. All of those will be decided this term. Typically, the courts the Supreme Court hands down its decisions by the end of its term, which is typically the last or second to last week of June. But that is not required by the Constitution. It's purely an internal working rule of the court. And so I suspect that what will happen is the court will simply extend the term, extend the term until such time as it can conveniently issue the opinions that are awaiting, that we're all awaiting, because they will have such important consequences. Is there any role that the courts are going to be playing in respect of COVID-19? Well, yeah, there may be. There may be different kinds of cases. There may be cases, for example, concerning the question of whether rights, constitutional rights, the right to assembly, the right to practice religion, the right to privacy, and in particular, the right or rejecting or not permitting unauthorized searches and seizures. All of those are rights that may be the fundament of lawsuits yet to be filed or being filed now. We'll come back to that in a moment. There are other opportunities. Perhaps there'll be cases arguing under the Fifth Amendment that lockdown orders in effect deprive private citizens of their property without compensation and without due process of law in violation of the Fifth Amendment. That's a possibility. We'll see. We'll see how that plays out. And then finally, there has been one case filed already, and there undoubtedly will be others, in which someone, and in this case it's the Attorney General of the state of Missouri, is seeking to have the courts declare that, in this case, the People's Republic of China is liable in tort for either deliberately or negligently inflicting on us the COVID-19 pandemic.
Dean, there's a question about that came in. So if
I'm
you
not
could
surprised.
expand on that.
Right, no, I'm happy to. That case, I looked at it yesterday, thanks to Kangdi Cheng, one of our first-year ILaw concentrators, who I suspect is probably the author of that question. Kangdi asked for a review of that decision, the case, or of that complaint. The case is brought by the Attorney General of the state of Missouri, acting as parens patriae, acting as the representative of the people of the state of Missouri. And they have sued the People's Republic of China, the Communist Party of China, CCP, and various agencies and instrumentalities of the Chinese government. As far as I'm concerned, and in addition, I think the Wuhan laboratory or something like that, all of the defendants that are the government or agencies and instrumentalities of the government will be dismissed out of that case, in my estimation, under the Foreign Sovereign Immunities Act, which severely restricts the ability of the US courts to entertain lawsuits against foreign governments. Now, there are exceptions. There are 7 exceptions in the statute. And one of those exceptions is the so-called commercial activities exception.
Right.
That's the one on which the Attorney General of Missouri is relying. He is saying that this is not, whatever it was that China or the agencies did was not a governmental function, it was a commercial function, that this had some pecuniary objective or something, and therefore it comes within the exception. The courts do not, in these instances, defer to the executive branch's recommendations as to who is and who is not entitled to sovereign immunity. They used to, but since 1976, they don't. Congress has claimed that power, and the Foreign Sovereign Immunities Act lays out fairly specifically how it's to be applied. And there's been an enormous amount of jurisprudence since 1976 interpreting the commercial activities exception. And I think there's very, very little chance that any of the non-government defendants will not be dismissed out of this case on the grounds of sovereign immunity. Now, what about the non-government offenders like the CCP, the laboratories, and things like that? Well, there is a case out there, and I'm not familiar with the case, I have to confess, but there is a case in which a court somewhere in this country, I believe it was a district court, has held that the Chinese Communist Party is not the government of China, and therefore it's not entitled to sovereign immunity. Maybe. I have a hard time picturing how that would work. And then the private defendants, the entities, the Wuhan lab and things like that, I suppose they could be sued. However, there are still going to be certain hurdles that the plaintiffs will have to overcome. One is they're going to have to serve process on those defendants, and that's not going to be easy, because to serve process, they're going to have to show that the Wuhan laboratory engaged in commercial activity in the Eastern District of Missouri, not just in China or outside China or even somewhere in the United States. They would have to show that linkage, and the courts have insisted on that. So I think the case is going nowhere. But as I suggested in chatting with some of the students yesterday, I don't think this case was filed in order to win. I think it was filed in order to get headlines. And
Which he did.
Which he did. The position of Attorney General in some states is a highly political position. In other states, it is not. In Missouri, it very definitely is. The previous incumbent of the position of Attorney General is Josh Hawley, who is now the Republican junior senator from Missouri. and very much a Trump supporter. So this is, that office is singularly political in orientation. They're obviously looking for some kind of resonance in the judicial system. I don't think they're going to find it, but they are going to get headlines in the meantime.
I have a question. Well, I heard that if they ever get to the merits of the case, the plaintiff would have to also show that they mitigated damages. And so China could actually turn the tables and ask what Missouri did or didn't do to mitigate damages, which would make it look too good. So I think that's pretty much going nowhere. Okay, well, let you continue because we want to leave some more time for questions.
Sure, I'm going to wrap up very quickly, just talking briefly about the obvious implications. I mean, too obvious really to belabor the obvious implications for things like freedom of religion, freedom of assembly. You know, people are complaining all around the country that they can't have church meetings, or they can't have political meetings, they can't have rallies, and that's true. So is there a constitutional problem there? Well, I don't want to go too deeply into this because my constitutional law class is not finished. Those of you listening who are in that class perhaps will gather what I'm referring to now. But I think that there are fairly strong precedents of the Supreme Court. And I don't think I'm giving anyone hints that they don't need when I refer specifically to the Division of Employment Services v. Smith, which has said, in which the Supreme Court has said that when there is a law of general applicability that is no more restrictive than is strictly necessary to accomplish its objective, and that objective is a pressing government objective, then the states have pretty wide latitude to issue such regulations. And so I think that those cases are not likely to go very far. Fifth Amendment cases, I think, will meet the same fate. Property has not been taken from plaintiffs, from property owners. You weren't, someone who owns a hotel, for example, like, oh, I don't know, a hotel on Pennsylvania Avenue and 13th Street, just for example, that person could be, would be hard pressed, I think, to say that government action was responsible for taking property from him. It wasn't government action so much as it was the fact that people are not willing to travel and not willing to stay in hotels. People are frightened, people are concerned. And because of that, we are seeing, I think, a rather troubling tendency to lash out. And I'll end with this. We're seeing demonstrations suggesting that somehow the maintenance of lockdowns and quarantines is unconstitutional on its face. Give me liberty or give me death. Well, obviously the response here is go do deny social distancing and you'll get both. How about that? You'll get both liberty and death. And of course, it won't always be you who is doing the dying. It may be the people that you infect who do the dying, including your elderly parents or international law professors or whatnot. But we're going to see that movement exploited. I would anticipate that it's going to become louder before it stops. I think that even when states begin to ease up on their restrictions, they won't be easing up fast enough or dramatically enough to satisfy people who are of the view that if something goes wrong in life, anything goes wrong in life, there's gotta be somebody to blame for it. And there's gotta be somebody I can sue. And there's gotta be somebody who at the end of the day is going to give me money to make everything okay. And I don't think that that is an aspect of the American judicial system that I'm particularly proud of, but it is a very important aspect of our system. So is there a continuing threat to the viability of our Constitution? Not if we don't let there be. Not if we insist that the rules that we've lived on continue to be honored, no matter who it is who is threatening to dishonor them. And the Supreme Court has not hesitated to call the President of the United States himself on the carpet. It happened with President Nixon regarding the tape, the Watergate tapes, and it happened to President Clinton when he was required by the Supreme Court to give a deposition in the Paula Jones case. So the idea that the Supreme Court can rein in anyone in the executive branch is well entrenched in our system. And even Youngstown Sheet and Tube is an illustration of that very point. Is there a crisis that will require major realignments in our understanding of the Constitution? Maybe. Maybe. We'll have to see. We'll have to see how firmly those of our public officials responsible for protecting the Constitution are in their resolve to do just that. You know, the president's oath of office requires him to protect and defend the Constitution of the United States. Whether we think this president has lived up to that oath or not, the point is that not only does it bind him, it binds the entire executive branch. The judicial branch is bound similarly, the legislature as well. And then finally, is it time to rethink some of this? To come back to that very first question I was asked, is it time to think of what international lawyers sometimes call positive rights as well as negative rights? Negative rights are the ones that say the government shall not, right? The government shall not ban religions. The government shall not deny the right to counsel. The government shall not torture. But what about things that international law, international human rights instruments say the government shall do, like provide the basics for a decent life, or for education, or for housing, or for health? Is it time for the United States to start looking in the mirror a little bit and asking the question, should we be protecting those rights, those positive rights in our Constitution, or should we remain under a regime in which the Constitution simply tells the government what it may not do as opposed to what it must do? I'll stop there if I may.
Bravo, bravo. We have a number of questions coming in, and so I will start right in. One from our very own iLaw professor, Daniel McGraw, our environmental law expert, who asks another question that has been very much on all of our minds. If an effective vaccine is developed against COVID, could a federal law constitutionally mandate vaccinations throughout the country without approval by states?
I think, you know, I know Dan McGraw reasonably well. I'm sure he intended that to be a trick question. I don't think it's a trick question at all. The answer is no. No, there is nothing in the Constitution that permits something like that. Now, you might say that if we have a vaccine, anybody who doesn't take it is a damn fool. Any governor that doesn't mandate it is equally a damn fool and should be thrown out of office at the first opportunity. But no, nothing is federalized here.
Correct. Okay. It will be interesting because we'll probably see a lot of movement from the anti-vaxxers in
I'm
this.
sure.
Any other, while other questions are coming in, I had a couple. One of them, just on your last point about the clash of First Amendment rights and the federal rights, the First Amendment rights and states' rights. Would you care to comment on what Attorney General Barr has said in terms of maybe having the Justice Department help with the state justice, have the Justice Department actually back some of the people bringing suits, questioning some of the stay-at-home bans from state governors?
Well, I think the answer to that question is that what Attorney General Barr is proposing is not nearly as dramatic as it sounds. When someone typically challenges the federal constitutionality of an instrument, whether it's a federal law or a state law, it is very common for courts to invite the government of the United States, generally through the Office of the Solicitor General within the Justice Department, to weigh in. Because after all, you know, the issue here is this statute or is this policy going to be found to be violative of the basic law of our country? That's a federal question, at least in part. And so if there are such First Amendment cases, and if Attorney General Barr or his department is asked to weigh in, he might do that. I'm not quite sure what the arguments would be, but I guess that well, I'm speculating, obviously, totally speculating, but it could well be that what he was doing when he made that announcement was simply saying to governors, please be careful, don't overreach, don't go further in banning religious services or political rallies, which have constitutional dimensions. Don't go further than you really have to. If you go as far as you have to and you have developed the rationale for it, we'll leave you alone. But if you go further, then we will reserve the right to jump into this litigation by agreeing with plaintiffs who are telling judges around the country that what you've done is not constitutional. I don't think he meant more than that.
Okay, well, just to let you know that Frosini also had the question on vaccines. So we have, the professors are all concerned about vaccines. I think it's thinking in terms of a countrywide solution, which is not really going to be coming. So another question from one of my students, Britton Alfred, about the role of public protest and mobilization and challenging government and the constitutionality of decisions. So what are the implications of our inability to exercise our First Amendment rights to make demands regarding what states are deciding to do? I mean, how can you balance your First Amendment, freedom of association rights, freedom of speech, et cetera?
Right. And incidentally, Britain is my student too, so there.
Oh, good. Okay. So
very good one.
A double whammy, yes.
No, good question. The court, in reviewing legislation, or whether state or local, and usually is either state or local, not federal, that is alleged to infringe freedom of association, the court has been fairly, or courts have been fairly solicitous and open to the police powers argument that while speech cannot be regulated on the grounds of content, it can be regulated in terms of time, place, and manner. That is to say, there is nothing unconstitutional about requiring a parade permit if you want to have a march on the White House or a demonstration in front of the Supreme Court building. There's no constitutional problem with requiring that if you want to do that, you have a free speech right to do it, but if you want to do that, you have to apply for a license, you have to get a blessing from in this case, the Metropolitan Police Department, but whoever else it might be around the country. I think that the answer to Britain's question then is that the restrictions on rallies will be assimilated to time, place, and manner restrictions. That is, the courts will say, well, okay, typically we would not allow a demonstration involving bass drums to take place outside a hospital, a state hospital, because it would be disturbing. By the same token, we are not now going to allow a demonstration outside the state capitol that includes more than X number of people standing Y feet apart. I think that would be upheld as time, place, and manner, but again, it will be subject to some reasonableness test. And that could be, again, the marker that Bill Barr was putting down in this threat to participate in litigation on behalf of plaintiffs. As I said a moment ago, I think it's quite likely that what he has in mind is to say, sure, you got to do what you got to do, and I'm not going to tell you you can't, but be careful the way you do it and make sure that you're not going too far in regulating those areas as to which people will have the strongest argument that First Amendment rights are implicated.
Lots of questions, so we'll continue. One from, I think, another of both our students, from Sam Davidoff Gore, on how does the COVID pandemic impact the constitutional rights of prisoners?
Oh.
Yeah.
Yeah, a very good question. At the moment, as the media have been reporting, state prisoners, non-violent state prisoners, and federal prisoners for that matter, like Paul Manafort's colleague Gates, have been, and Michael Cohen for that matter, have been successful in asking courts to let them out, maybe to a system of home detention or ankle monitoring or something like that, to serve the rest of their sentences, or at least those parts of their sentences, until the emergency is lifted. the argument could be made that requiring prisoners to remain in confinement in very close quarters, eating presumably in mess halls where people are shoulder to shoulder, using the same utensils, exercising in the same yards, visiting the same bathrooms, shower facilities, conference rooms, that the exposure to COVID-19 may be sufficient to justify the claim that is in effect subjecting them to torture or subjecting them to some kind of impermissible abuse. It's possible. I think it's hard to imagine that, though, because of the consequences. I mean, just take the case that in which my firm and I are representing a man on death row in Alabama that Professor Gardner mentioned at the very beginning. He's on death row. He can't be let go.
No.
That doesn't make sense. And so if his, if there were to be some form of social distancing imposed on him, it would likely be to increase the level of restriction that he's living under rather than to decrease it. It would be to reduce the 1 hour a day that he is today allowed outside of his cell to maybe no time at all. Maybe he will not be let out of his cell at all in order to protect him from COVID-19, but at the same time to expose him to the psychological dangers that we all know solitary confinement brings in its wake. Incidentally, I got to tell you one anecdote just to stray from the point for a moment. I had an email the other day indirectly from my client on death row who told me that in his prison, the guards came around offering masks to the inmates, and he turned down the mask. He said, "I don't need it. The nurses need it more than I do."
Oh my God.
Yeah. And I pointed out in response that I would be very surprised if even one of the jurors who put him on death row in the first place would have reacted that way.
Wow.
Anyway, sideline.
Okay, other questions. So Haridas Ramasamy, don't know if he's one of your students, but
Nope.
question, does the provision of federal funds through the declaration of federal emergency give the federal government the ability to arm twist state governments to do their will?
Maybe. The courts have justified to some degree the power of the federal government to put strings on government grants and to require that they be used for certain purposes. For example, the litigation went through the courts for a long time concerning whether road construction funds, grants, could come with the string that says you must impose a 70-mile-per-hour speed limit. Western states strongly opposed that. And they didn't want to turn down federal money. Who would? It's free. So I think the answer is that the states are or may be required to do the federal government's bidding so long as, again, it always comes back to this, so long as there is a justification that can be tied back to a constitutional power granted to the federal government. In the case of the speed limit, it's obvious. The traffic on whatever it is through Big Sky country in Montana is in all likelihood interstate travel, just as the clientele of the Heart of Atlanta Motel in Atlanta, Georgia in 1964 was held to be in interstate commerce in the Supreme Court's decision justifying the Civil Rights Act of 1964 based on the notion that it has roots in the Interstate Commerce Clause. So I think the answer to that is a guarded one. If there is a federal basis for imposing this kind of restriction that is a federally justifiable, a constitutionally justifiable basis, then yes. If the federal government were to tell the states, we'll give you a grant, but we want you to spend it on buying supplies from this company rather than that company, then obviously no.
Okay, another question. In recent news, we've seen some states like California that it's claiming that it'll purchase PPE and other counter COVID measures as a sovereign state. To what extent does the U.S. Constitution grant states this sovereign state status, both domestically and internationally?
Well, internationally, of course, not at all. The states may not have their own foreign policies. The Supreme Court has said that umpteen times and continues to say it whenever asked. And again, my students will have heard the story of the case of Fisher against Turner, in which I argued in the Ninth Circuit, in which the court said California, in that particular case, may not have its own foreign policy with respect to compensating Holocaust victims. So, okay. But domestically, different story. The states are, in many senses of the word, sovereign. And that's the point that I've been trying to communicate here. The states are, to a very large degree, sovereign. Now, here's an interesting little twist to that. The Constitution provides that the states, reserve all their police powers and all their non-delegated powers, et cetera, et cetera, et cetera. And they may act on their own. But the Constitution says that they may not enter into agreements with each other to accomplish those objectives. That is and I'm looking for the citation to this now. Here it is. The Constitution at Article 1, Section 10 says, no state shall, without the consent of Congress, enter into any agreement or compact with another state. So that would seem to mean that the state of California, for example, it's a very big place. It has a very big marketing footprint. It can command a lot of respect in the marketplace. It can't bring in a smaller state, Nevada, for example, or New Mexico or Arizona, and say, let's do this together. It seems that that's the meaning. But the Supreme Court has said no. The Supreme Court said as long ago as 1893, in a case called Virginia against Tennessee, one of those cases, incidentally, where the Supreme Court has original jurisdiction. It's not hearing an appeal. It's actually acting as a trial court. There was a compact made involving water rights between Virginia and Tennessee, and the party, and I don't remember which it was, I'm afraid, the party that wanted to overturn the agreement said, oh, it was unconstitutional on its face. And the Supreme Court said, no, no, no. Again, we have to read the Constitution reasonably. We're not going to read it as absolute. Where it says no compact shall be made without consent of Congress, we certainly do not want to be troubling Congress every time the governors of Virginia and West Virginia make a deal that allow, I don't know, college students in one state to get in-state tuition in the other state. That's ridiculous. Congress has more important things to do. So that door is open, and the states may either alone or together act in order to purchase PPE, to purchase ventilators, to purchase other equipment that they feel they might need. And there's nothing in the Constitution that stops them from doing it. Obviously, the more of them get together, the stronger they're going to be. In unity, there is strength.
We are running against time. Can we take 5 more minutes? Is that okay? Or
that's tech people. Okay by me, but Kensei, are we all right with a little bit more time?
Yeah, sure.
Okay.
Okay.
Okay, just I actually had a few more questions myself, and there are others, but just wanted you to comment on what is happening in terms of non-essential, the decision of non-essential and essential businesses. So a number of states like Texas, Nebraska, and Mississippi have decided that abortion is non-essential.
Right.
Clearly, this runs against some Roe v. Wade issues, and I was hoping that you would comment it because the time it would take to get this to the courts might be a little long.
Good, thank you for that. It was in my outline. Unfortunately, toward the end, I had to start skipping a bit. But yes, states that are restricting non-essential services are frequently including medical services. And sometimes they're doing that on sort of their own notion of what essential means. Other times they're tying the essentialness of medical services to the availability of, or the need for personal protective equipment, PPE. The states that are saying abortion is a non-essential service because we need PPE for abortion, obviously that would apply to surgical abortions, but not to medical abortions. The states so far, including Texas, that have attempted to use that rationale to justify a total ban on abortion have not met good results in the courts, including the courts that are typically most hospitable to those views. So the answer to that is no. However, yesterday, only yesterday, the Eighth Circuit Court of Appeals in St. Louis reversed the decision of a court in Arkansas addressing an Arkansas state policy that said that all abortions will be permitted, both PPE ones and non-PPE. The Eighth Circuit said it is perfectly logical to draw the distinction between those requiring protective equipment and those not. And once we know that we are rationing PPE, we have to use a rule of reason, just as we do with every other allocation of government benefits. And so saying that abortion is less important because it's not life-threatening than coronavirus or than heart failure or than in extremis cancers is rational. That's what the Eighth Circuit said. It may end up in the Supreme Court. I doubt it. I think that'll probably be where the line is drawn.
Question from Professor Appleton. Is the Public Health Service Act a sufficient grant of congressional authority to allow the executive branch to make and enforce quarantines and isolation measures designed to prevent the spread of communicable diseases?
Yeah, that's an interesting question. I don't think so. But that doesn't mean that this executive branch isn't going to try to squeeze that juice out of that lemon. They may very well do that. But I don't think that the Public Health Service Act confers that power. And again, I think if it were read to do so, there would be the underlying constitutional problem that to read it that way turns on the court's finding that the federal government has a right, has a power, has an authority that the Constitution does not grant.
Okay. I think we should close here, hoping that we will not have a congressional dereliction of its authority to have some kind of congressional legislation on for our November elections, because clearly if the Congress does not act in terms of giving us the possibility, all states a possibility of having absentee ballots, this will be left to states and it could be quite messy, correct? If you could just finally comment on that as we close, because that is sort of weighing on everyone's minds. We've got an election, a very important election coming up.
Yep.
So what happens?
It's going to be messy. You nailed it. It is going to be messy because the Constitution says that the states may make the rules concerning eligibility for voting. Obviously, we know there are some constraints. They can't discriminate based on race. They can't have poll taxes. They can't have so-called literacy tests. They can't, et cetera, et cetera, et cetera. But we know how broad their mandate is because they're allowed to gerrymander the, you know what, out of their state maps. So if they're allowed to do that, then they will be allowed, I think, a great deal of latitude up to the point of denying access to the ballot itself, up to the point of making the argument that there's a denial of due process. However, even though when the Supreme Court handed down the dreadful, indefensible decision in Bush v. Gore, they said, don't take this as a precedent for anything else that might ever happen. This is a unique situation. The court in that case showed the lengths to which it will go to preserve states' rights to do what they please in the context of eligibility, the conduct of elections, the counting of votes, and all those other things. So we are going to be in for street-level fighting on the question of state legislation that is aimed at addressing that problem across the country, and then judicial review in those places where the ACLU and other organizations, the NAACP, challenge those state rules on the grounds that they bring about something less than equal protection of the laws.
Well, I think we'll close at that. Thank you, Professor Extraordinaire. We really, I think this was an extremely important and timely webinar. A number of our colleagues, I think a lot of us weren't sure whether constitutional law sort of fit into the COVID thing, and I was really pushing for this seminar because I think that these are the issues that are that we are hearing every single day on the radio and on TV. It's absolutely critical. We are very lucky to have a constitutional law expert in the International Law Department. This professor spans everything. And I think this has been extremely interesting. There are tons of questions in the Q&A that I was not able to get to, and so maybe we will you will be able to take it offline with the students. But I wanted to thank the students for really, and professors, but mostly the students, for having provided some excellent questions and very thought-provoking questions to what was an extraordinary hour and 20 minutes.
Well, thank you very much, Nina, and thanks to everyone who joined. And incidentally, if there are people who have questions about the Constitution and how it all plays together and these things, I have a constitutional law class. There's one more session on Monday evening. So if anybody in the sound of my voice is interested in perhaps joining that class, some of these issues will come up then, and certainly there'll be time, I hope there'll be time for questions about the issues we talked about today. So contact somebody in the class, get the link, or send me an email and I'll give you the link, or Denise can give you the link, and we'll go from there.
I think you mentioned that since the election, this last election, your interest in constitutional law has skyrocketed.
It has. I wonder why.
Well, the interest in this particular subject today with regard to COVID has kept everyone enthralled. So thank you very much. And I'll close it at that. Thank you, everybody, for joining.
Thanks. Bye-bye.